9 people confirm.
Okay.
And I've got a little bit more than that. So that's good. Lucy Play, called me and she wasn't going to be able to make it. She had a family matter come up.
Okay. Okay. So want to begin. First of all, Beth, thank you for arranging this, and thank you for all the hard work that you've been putting into the zoning department and everything that goes on and around that issue. It's very much appreciated by the Board of Trustees. And I want to thank everyone for attending tonight's training as well. I know that you all probably had a very busy day, and this just adds on to it. Your commitment to the township is greatly appreciated by the Board of Trustees and by staff, because really without you, we would not be able to do what we do, not only for our residents, but for developers and all of the general contractors and other clients that we deal with on an ongoing basis. So thank you for your volunteerism and your commitment to your community. It's really greatly appreciated. We felt it was important to do on an annual basis a training to kind of refresh people's memories in regards to roles and responsibilities. And I know we have some new folks in some different positions. So we thought it was an ample time to kind of hit some high points in regards to what the role of the responsibilities are of the 3 boards that we have in zoning, and what are the expectations that you all have from our standpoint, as well as those coming before you on a regular basis. So I know that our outside firm, Brochus, Johnson and Griggs, they're with us tonight because they have served in the capacity of our outside counsel on zoning matters for some time, and are very familiar with us and other townships. And I think we'll be able to give a great insight into some of the best practices as we move forward and become even more professional of an operation than we have been. So with that, is Jen going to be doing the training tonight? Is that correct?
She is.
There she is.
I appreciate that, Chet, and thanks everybody. Some of you are familiar faces to me and some not. So I'm Jen Cooper. I'm a lawyer with Brochus, Johnson and Griggs, as Chet mentioned. I have had the privilege of doing zoning work with this firm for 6 years this year. I do a significant amount of zoning. I work with townships all over the area, and I don't say that to make you, impressed in any way. I'm saying that I get to be lucky and do this on a regular basis. It's not something I have to kind of get dropped into. In fact, COVID took away a lot of my social engagement with so many of my zoning friends, and for that I hate it. But I'm glad to be able to do this and be here with you virtually. So as I see tonight, and since I have you for about an hour, and I have a lot of you for about an hour, I see this as a booster shot, which is a bad pun, to your already good knowledge and great knowledge of what you do in your capacities. And at any point you need an influx of new information, or a question comes up, that we're always here. My information is probably widely available on the internet, on our website, and different things. So I have commission and board members call me on an occasional basis and just say, hey, Jen, this question came up, or I was thinking about this, or I saw this, and what do you think? I think we also have a resource in sort of a silver lining, being that COVID has made so many bodies go to virtual means that weren't doing that before. And so in that same line, there's so many video recordings that you could even watch for fun, or if you can't get to sleep some night and you just want to hear someone's voice kind of lull you to sleep. But I think it's a good resource for me to kind of look in and see how other people are doing it, learn some things, learn what I like, what I don't like. And so that's a resource too. If you ever, it's as easy as going to the internet, Googling Ohio Township Zoning Commission or Ohio Township BZA, and see what people are doing and give some examples. But I want to make the best use of your time this evening. I appreciate you being here. At any point, if you have a question, and if I don't see you or if I don't hear you, just flag me down. I want you to ask it when it's fresh in your mind. I think that's useful to all of us. So I'm also, you probably have the materials that we put together. Those aren't exhaustive, but they are long. And so I'm not going to read through each page of that. So if I go past something and you say, hey, I flagged that for myself and I'd like to talk more about that, just bring me right back to it. We absolutely can. I want to hit the highlights. So what I'm going to do, because I have so many different bodies here tonight, and obviously you each have different jurisdictions and roles, I'm going to, at the risk of confusing anyone, try to start with going through these frameworks that you probably have, these documents that we put together. There are a lot of things that you share, not jurisdiction itself, but how you got this way, how you got this power, how these boards got created, then delve into each separate body's distinct roles, and then come back a little bit at the end if there's time for a little bit of the ethics, which my rule of thumb for ethics is, if it feels icky, there's probably some truth to that. And I think that's a good rule of thumb. And if something feels like I can't put my finger on it, you might be on the hunt of something there. So any questions before I kind of dive right in? All right. So I'm going to start, like I said, with some of the general overview, and I'm going off that framework that I provided. Zoning is zoning is a police power. Townships don't have, and you hear that word, you think, not only when I was in law school and I heard that word, I thought, oh, they mean law enforcement. It's not just law enforcement. When people talk about police powers, they mean all of the sort of the real life powers that that any local government or governmental entity has. How do they affect the health, welfare, well-being, lives of folks where they live? Townships don't have each and every police power. You know that you don't have the ability to levy an income tax, for example. And you don't have the same police powers that cities do. So that's an important distinction as well. If you see somewhere that a city's doing something and you think, well, why aren't we doing it that way? There might be a reason, it might be that. Cities draw their, we'll call it home rule. They have full home rule. Perry has limited home rule. Townships can only get to that limited. Cities have their home rule power. They draw it from or from the state constitution. Townships only go as high as state statute to get what they have. You don't have true home rule out of the Ohio Constitution itself. So that's when we say townships are creatures of statute and you have only those powers that come from statute. That's what we mean. Chapter 519 of the Ohio Revised Code, again, if you fancy yourself, needing a light read before bed, the Revised Code is an excellent place to start. It's put me to sleep many times, even though I didn't want it to. Chapter 519 is where that zoning comes from. Almost all of your zoning authority and what we typically think in the big category of zoning comes from Chapter 519. There are a couple places where you'd pull it from other sections throughout the code, but that's really your bread and butter. Constitutional limitations. When a case, and this really comes when somebody says, oh, I'll have to argue about zoning being constitutional. Really, my resources as a zoning attorney come from a couple places. Statute is the best place. The Attorney General's opinions sometimes delve into zoning, not as often as other things, but there are some good Attorney General's opinions. Those are good. And case law. So if I don't have a statute and I don't have a case and I don't have an Attorney General's opinion, there's very little for me to go off of. But when zoning cases go up to any of the local courts, certainly the Ohio Supreme Court, or in certain instances, the United States Supreme Court, we take notice and we take note of that because those affect us. Zoning is legislative. So courts don't often get into, whether we made the right decision. Township, I wouldn't have done it that way. That's not really up to the court. Whether we followed our code is up to the court, could be up to the court. Whether the law in the first place was an overstep could be up to the court. But as far as, we would have let that building be 17 feet instead of 16 feet. I mean, that's not usually, a court doesn't get to institute or substitute its judgment for the township's judgment, for the legislative authority's judgment. Courts can decide whether the zoning regulations are so unreasonable. So that's where I'm saying, if they're looking at a statute or our code or any of our provisions, they would have to find it so unreasonable and arbitrary that, you know, and that goes into the lawyer's favorite reasonable person standard. What would a reasonable person do in a similar situation? Is it beyond that? Is it well beyond that? And that's what would place it into that realm. Otherwise, we're entitled to and enjoy the presumption of constitutionality. It has to meet a pretty high bar to be found unconstitutional in a court for a zoning regulation. That being said, something short of unconstitutional, but that does trip people up or does trip all kinds of governments, not just townships. If a code of any kind is unclear, if a provision is unclear, if it would go to court, the court's going, you've probably heard some lawyer in your life tell you this at some point, the court's going to construe the ambiguity. So to the extent we can't really tell what it says, or it might say one of two things, the court's going to find in favor of the thing or their interpretation that lets the property owner do what they want. That's American property law. We take that all the way back to, King George can't tell us what to do. It's our space. So if the zoning provision or the code isn't clear, if the court decides it's not clear, they're going to find in favor of, they have to go one way on the seesaw, they're going to go in the way of the property owner being able to do what they're trying to do. Now, when somebody in that same line of rationale, if somebody, if you've been familiar with the concept of a taking, that would be a governmental body taking property, using it for its own, and that doesn't always mean taking it in whole, right? Taking it fee simple down to the very dirt or below. That might mean, hey, if you put this utility line there, I can't use it for my kids' play. I can't use it for their play gym, or I can't use it for my own satellite dish, or I don't know what. So in theory, the government, it has to be a governmental actor. It can't be my neighbor put something there, now I can't do what I'm doing. It has to be a governmental actor is using my property over my own rights, and now I can't do something I wanted to do. That also is a pretty high bar, and also the governmental body gets some pretty substantial leeway, because again, that's one of those rights we give up to live in a democracy, I guess. That the governmental bodies that govern us have to have some leeway to do what they need to do, right? If a utility line has to go through to get so-and-so down the street, their electric or their cable or their water or their whatever, then there has to be some derogation of my property rights to be able to get that there. But that's not absolute. So, but the standard is under the takings. Has the governmental actor deprived me of all reasonable use, all feasible use of the property? It's quite high. It wouldn't be enough to say, well, but they did something and now I can't do this one thing with it. That won't be enough. I did hear a story that a lawyer tried to argue a taking or made the mention pretty inartfully to a client township of mine, that the township, it was a zoning commission. She was up front of rezoning on a residential rezoning to a planned development. And I think she was trying to say, if you don't, I don't know if this was hard. I don't know what she was trying to do with it. I don't think it was professional or anything, but if this isn't granted, it's a taking. And I hope you can see from my face that was the same face I made on the phone when I heard the story. But you can build, so it's zoned agricultural underneath, and under that township zoning code, they could build homes. They could build homes right now under a straight district, under the district they're under, just not 4 to an acre, 5 to an acre. They might be bigger lots. So I failed to see, that's maybe I'm trying to give an example of a practical situation where somebody may say it's a taken and all you have to do is kind of shrug your shoulders and scrunch your face together and go, yeah, I don't think that's going to meet the all economically viable use threshold, and it didn't get her any further forward than it did, than you'd expect. That being said, there are some prohibitions in the statute or in various places in the Ohio Revised Code about what we can't zone out or what we can't regulate. Probably notably to you, you probably know there's a very strong agricultural lobby, and as the proud granddaughter and niece of people still farming every inch of their land, I get that. But it gives me heartburn every time a zoning inspector calls me and is like, well, I got an ag question. So ag has a very strong statute, 51921, about what we can and can't do as far as prohibiting, regulating, not only the act of agriculture. So if I was wanting to raise horses, or I wanted to build a barn, it could be both of those situations where I might say, you know what, they meet the restriction or they meet the requirements. So the biggest blanket under that statute is if the lot is greater than 5 acres, I can't do much of anything to prohibit them being able to either raise those horses, build a barn. I don't care if it's build a barn and there's no house, build an accessory structure without a principal structure. They're going to be able to do it if it's agriculturally related. And then you're going to ask me what's agriculturally related, and then I'm going to tell you that's a whole other training session, and it's 3 hours long. So if anyone has any particular questions, we absolutely can discuss. But that's one of the big exceptions out. Outdoor advertising has some special protection. So do cell towers. Again, I think that falls, if I were a legislator, I would say, well, that kind of falls along the same lines as a public utility, getting some leeway. You know, we all want our cell service. We all want it to be good. We rely on it for meetings like, well, not necessarily cell, but for meetings like this one, that it's so important. And then that's why they get some leeway on what they can do and not do. Additionally, there's a category called lawful nonconforming uses, which basically means those grandfathered type of uses. If a use was there before zoning started, that person has a vested interest in being able to use their property that way. Even though we have said, no, you can't now use it that way, they're going to be allowed to use it that way, not expanding it, but they're going to be able to use it that way until the use changes. It doesn't matter if the property sells, it's the use. They're going to be able to continue using it that way.
What if it's destroyed beyond a certain percentage, Jen?
Say that again.
If the structure is destroyed beyond, say, 50 or 52%, can it be rebuilt without a variance then if it's a non-conforming grandfathered use? It
would depend on all the facts. They may be able to. If it wasn't their own action, it would be clear. Your question would be a clearer yes or no if they did something, right? A property owner, I don't know, took off the shed where the back half of the house where they were running their business. But then the next owner, 2 owners away, said, no, we want to bring it back. And we heard that a couple of years ago, a couple of owners ago, someone was using it as this, and we want to go back to using it as this. Nope, it's done. I mean, it's done. There has to be a break.
Yeah.
Often codes address that by saying if it's been abandoned for a certain amount of time, the use has been abandoned.
Time, yeah.
Yeah.
Okay, I'm with you. Thanks.
Mm-hmm.
Hey, Jen, back to cell tower just quickly.
Sure.
If it's zoned residential, then we can regulate cell towers.
That's right. And I'm glossing over some things, but that's a critical distinction. It's not an absolute. I don't want anyone to think that these exceptions are blanket. They're not. Even the ag exception is, well, if the lot's under 1 acres, but not more than 2 acres, or if it's less than 5 and it's in a platted subdivision or a subdivision. I mean, there's all kinds of caveats. And that's why it gives me so much heartburn. But you're absolutely right about the cell towers. It's not an absolute. You can't. There's certain situations, very specific situations, where you can. You can. And you're right. It's about being in a residential area. Mm-hmm. But it's not in a residential area. There's not a whole lot we can do. Let's see. I have a couple other notes on that section, but I was going to dive into a little more zoning commission specific information, unless anyone wants to go into any detail on the prior sort of general topics. Okay, get to the meat and potatoes, Jen, and let's talk about some interesting. Okay, great. Okay, so this is the zoning commission. You're regulated under chapter 519, this typical zoning section. That governs how many people you have, how many alternates you have, how you get those members and alternates. The zoning commission often, almost always with an asterisk, acts legislatively, meaning you act legislatively like the Board of Trustees acts legislatively, in that you're adopting legislation in a sense. You might be in a two-step process where it comes to you and then it comes to the Board of Trustees. You might be, adopting legislation just like they are. It's just there's two groups that look at it, and if the buck stops with the trustees, but it started with you. It's a bookended situation. So that's how you act in the legislative capacity. The asterisk is when you're considering a rezoning of an overlay or a plan district, you're acting not legislatively, you're acting in an administrative capacity. When that goes back up and you make that recommendation of how you recommend approval, denial, approval with modifications. And that's because that action isn't really, it's more applying the code than it is enacting code. So that's the distinction there. You act in both of those capacities. You do not act in the quasi-judicial, this is the zoning commission. Zoning commission does not act in a quasi-judicial capacity, acting like a judge or a bench of judges, like the BZA does. Only the BZA acts in a quasi-judicial manner. And I was going to show a quick clip to illustrate that, if I can get technology, hopefully, to agree with me. Let's see if this works. Okay, can you see my screen?
Mm-hmm.
Excellent. So this is a zoning commission. This is not my client, would never put anyone on blast like that.
The Westchester Zoning Commission.
Can you hear it?
For September
A little bit.
2020.
Turn it up if you can.
Mr. Dawson, roll call, please.
Better?
Here.
Yes.
Mr. Grove? Here. Mr. Rogers? Here. Mr. Murphy? Here. Mr. Get your staff report for this case. I'd appreciate it. Thank you, Mr. Chairman.
Oh, I skipped the part I wanted to do.
Westchester Town Center, the residence is at the clock tower.
So they're hearing a rezoning.
Could you please raise your right hand? And I'll swear you in. You swear the testimony you give is true and correct to the best of your knowledge and belief. Excellent. And then we'll need you to swear in anyone that plans on giving testimony.
Okay. So you will probably notice, they swore in. They swore in their folks, which I can't say is wrong, don't ever do it, but it's really not something that the zoning commission needs to do, because you're not sitting as a quasi-judicial body. And so the people speaking before you are not providing testimony. They may be providing public comment, but their comment does not need to be sworn. Again, this is all the zoning commission. So that was something I was going to highlight. Is it fatal that they did? Probably not, but I think that illustrates a little bit of confusion on their end, that, if they're sitting as the zoning commission, they don't need to be, that's above and beyond, at least, and possibly confusing to folks who think, wait a minute, what's happening right now? You also, I know that you also have an architectural review board, and that's separate from the zoning commission. I did highlight in the materials that if you didn't have a separate board for the ARB, the trustees could have delegated that authority to the zoning inspector or the zoning commission, and that's under statute. What I will also note, and I have some other additional thoughts about the architectural review board, is that that body sits and exercises a code a little bit outside the zoning context. The code, I mean, they're still certainly in the zoning realm, but their code is not the zoning code. Obviously, they have their own. Their code does not need to follow the exact same procedures that the zoning code follows. It can be amended in a different way. So I wanted to highlight that. This is critical to both boards. You should have and be familiar with your rules of procedure. We often tell people, and townships across the state, especially in Central Ohio, are feeling more activity, development activity, certainly development activity than maybe they ever have. I mean, I've been doing this for 6 years, which I have coworkers who've been doing it for much longer. But even in that 6 years, I've watched the influx of development. I mean, it doesn't take a rocket scientist to see the MORPC studies come out and say, oh, we need however many thousand new homes for the influx of people, and know that that's how that's trickling down. It's trickling down to all the local government entities that have to hear these, or have been hearing, or continuing to hear all of these applications and requests. So your rules of procedure are really critical in helping you run a good meeting, have a plan, stick to your plan, and then have people, your attendees, your rabble rousers, all your folks who like to come and talk at meetings, know what to expect. And, you know, if they get some guidance that they don't particularly like, you know, when the lawyer or the chairperson has to chime in and say, listen, like, you've had your chance, or you've talked, or you've, you know, whatever, we told you this is how this is going to go, then your rules of procedure are really your anchor to back you up on that. Those are administratively created. I know that all of your bodies have them already. And they don't need to be updated every year, but certainly you should familiarize yourself with them and know what they say. Update them as needed. They would contain sort of they're sort of your bylaws, if you will. If you were a corporation, or you were an association, you'd have bylaws about how the meeting's going to go. And that's where you keep that information. Time and place of regular meetings, how you're going to call a special meeting, who speaks, how they speak. Now, certainly COVID has put a wrench in all of that. Even if you had the most beautiful rules of procedure written down before, I bet you anything that everybody I represent has had to look at those and go, well, shoot, how do we work around this, work with this, or amend them, or, you know, in COVID, do what we need to do to make it work. In this time last year, I would have told people, you know what's good? It's good to have people come to make people who are going to speak come to a podium. Not because there's a legal requirement anywhere that says that, but because it's good formality to make someone talk to you, talk to the board one-on-one. This is good advice, in my opinion. This is good advice for everyone, for all boards, not just pick anywhere. Make someone, you know, think their thoughts, come up to a podium, speak their piece. People will say different things if they're allowed to sit comfortably in their chair, flanked by all their people who think like them. It helps give a sense of formality, and you know, you're standing before an appointed or elected board, depending on what board. You know, if you're standing before the board of trustees, these are elected officials. If you're standing before any of these zoning boards, these are appointed members of your community. You're serving in a public space, and that commands and should deserve respect. Unfortunately, we've all seen far too many times, where people don't understand that, or don't feel like that's something they're willing to do. But certainly increasing the formality, making sure people address the board and not each other. And these are some ways you can use your rules of procedure. The zoning commission has a little more leeway because the BZA is sitting quasi-judicially. We take testimony from, I would advise taking testimony from a lot of people. There are very few people I would cut off, or very few situations where I would cut off, because again, I want the record to be clear. But the zoning commission can do a little more. With that. You'd still want to hear from everybody, because these are also the people who can either put your decision on referendum, in certain circumstances, appeal it under Chapter 2506 of the Revised Code straight to common pleas. But those are and I am going through these a little fast, and I'm hope that's not confusing anyone. But these are the kind of thoughts I want you to think when push comes to shove on a situation like that. Certainly, you need to keep good records of your proceedings. I know you all know that those records do not need to be verbatim. Minutes are never verbatim. There's no requirement that it be. I know we've all We've all been recording ourselves for the internet, and that's almost made that job a lot easier. And a lot of townships have gotten up to speed on that as well. Zoning commissions do not have executive session, nor do architectural review boards, nor do BZAs. I will put an asterisk by BZAs, and we'll come back to that later. But none of these boards can do executive session like the trustees can do executive session. That provision in 121.22 of the revised code is not extended to the zoning bodies. So good, bad, or ugly, you make those decisions in an open session, again, with the asterisk being the BZA. They do have an ability for private deliberations, which we'll talk a little bit more about. Comprehensive plans is another hot topic on my zoning commission list. We often are asked, what is a comprehensive plan, especially in the world of accelerated rezonings, increased applications. A question, if an audience member latches onto the idea or we've seen this happen where someone pulled out a copy of the comprehensive plan and says, well, it's not under that, or that's not what that says, or fill in the blank. And certainly the comp plan is a good resource. So what I will highlight about the comprehensive plan, it is required by statute. And as with lots of statutes, that requirement has been fought over in court many times. And I have a little bit of the case history in this summary materials. And for any group that any body or member here tonight that wants any of the other materials, I'm happy to provide them. I'm sure Beth would be happy to provide them. If you have something for the other group, but you're like, hey, I'd like to see that as well. If you don't have that one, I'd be happy to send it along. And most recently, the point being, zoning may be, this is the statutory language, zoning may be enacted in accordance with a comprehensive plan, which has generated all of the litigation over the years. Well, what the heck is a comprehensive plan? What meets it? What we know is that it can be pretty fluid at this point, short of another case telling me I'm wrong on what I just said. There are most recently, we were involved in this case. This was 2015. Most recently, the court has said a comprehensive plan doesn't need to be separate. It doesn't need to be a separate document, but your zoning code does need to envision and establish a coherent plan, that zoning has been enacted in accordance with some master idea for planning, essentially. That can be in counties or in townships where they don't have zoning or don't have as robust zoning. There's also a court case that says, hey, you can use the counties. If the county comes up with a comprehensive plan, you can use theirs. So if you ever hear that term, I mean, I'm sure that Perry has a land use plan, so you're not relying on the counties, and I know you have yours. And but just in case that, you put that flagstone in your path and know that that's where that comes from. It's a statutory requirement, but what it specifically is more fluid than just, you don't have to do the fire drill of oh, where is that? Who has that? What does it say? Because that has been established down through case law over several years now.
Jen, is the zoning map also, if the zoning map is conclusive of the whole area, is that a good exhibit for a comprehensive plan too?
Yeah, and your map is part of your code. Essentially, your map has been incorporated as part of, so it's like your map and your code, so the text and the picture and the map, and the comp plan. So your text and your map, those are law, those are legislation. Your comp plan is, we'll say it's guidance or it's regulations. It does not have the same effect as the code. But those documents should be consistent. You wouldn't want them to say, well, on the one hand, this area says it's supposed to be, high commercial, and here it says it's supposed to be low density residential. Certainly, you wouldn't want that juxtaposition. You want them to be pretty darn consistent. That being said, you do not have to. I mean, no township I know updates their comp plan every year. Those are usually 5+ year plans. Obviously, now everything moves so fast and changes so quickly, but That's not something that, you have to, that has to be updated every year. I don't know anyone who does it every year. I will hit a couple more high points specifically for zoning commission, and then I'm going to switch over to the BZA. So zoning amendments. If a zoning amendment comes before you, it can come, and that's a big category of items that the zoning commission reviews. Those can come before you because they started with a motion from the zoning commission. They can start on motion of the zoning commission. Sometimes they do. If you have a text amendment, you may be the ones to initiate that. Alternatively, the trustees can initiate zoning amendments that come before you. That's also a very common way. And thirdly, by the filing of an application for an amendment by one or more owners or lessees of property. And that's what often happens when you see an application for a rezoning. So a rezoning is a zoning amendment because we're changing the map. So it's an amendment. And I won't bore you with the detail, with the gory details. I will say that Don Brocious, if any of you knew him, former partner in this firm, he passed away a few years ago, was fond of saying, he told me, I can't tell you how many times that the section of the code that talks about zoning amendments and the levels of notice you need to give, who you need to give them to in the case of a zoning amendment to even get to see the zoning commission is he liked to call it a trap for the unwary. Jen, it's a trap for the unwary, and you need to pull the statute out each and every time. And I do. He is absolutely right. I pull it out each and every time because it goes down to the nitty gritty of if the application is to rezone 10 or more lots, 10 or fewer lots. And I mean, you just have to, it's sort of a, there's like pick your own adventure novels or pick your own adventure charts. It's like that. You just have to go like, okay, what do I have here? Yes. Okay. Well, I don't have that. So I need to go this way. And now I have, so it's important. There are a lot of requirements there. And that's a very important statute that we want to be sure to follow. But a lot of it happens before it gets to the zoning commission. A lot of it happens at staff level of notices that need to go out, whether they need to get published. But I want it to be on your radar that there are a lot of things that sets the deadlines, how quickly you need to make a decision on an application once it's before you, what the trustees do with it once you send it to them. That's the statute that sets all of those requirements out. I will note that one change happened recently to the statute a couple of years ago, where before all townships needed to send an application for a rezoning or a zoning amendment to regional planning. That change was there's a change to the statute made in the last 2 years, where now if the township has adopted limited home rule authority, which Perry has, that's optional. You certainly can, many certainly still do, but it's not a requirement to send it to regional planning anymore, where it used to be a requirement. And you would wait for their recommendation, you take their recommendation into account, et cetera. It may be the township's procedure to still send it to regional planning. They're a great resource, but I wanted you to be aware that it's not an absolute requirement anymore as of a couple of years ago. I think another point I was gonna make about zoning amendments is that I think it's very useful to be clear. Whenever you have a high stakes application, and rezonings often are, especially in this day and age, I mean, very few times are you getting rezonings for one lot, right? Jennifer Huber's lot, she doesn't want it to be a house anymore. She wants it to be a Dairy Queen. You're not getting those one-offs, or I'm not seeing very many of those. I see, so-and-so, a developer put together several acres of land. They want to do this project. So certainly those are higher stakes projects. We want to be sure, and this is something I will emphasize to every zoning board member I ever talk to, that the importance of creating a good record, of being clear in what you're doing. And if for any reason, if you think something's unclear, or you as a board member think, oh, that motion, I thought what I was voting for was X, but maybe I misunderstood. It's important in that moment to get it clear. You might not have another opportunity, and that decision will become the decision. And that's what could get, depending on your board, appealed, referended, I mean, all of that. So it's important to be clear. It's important for, me as a lawyer to be looking at something later that I'm being asked questions on that is thorough and clear and sets out rationale is important. Those are my highlights on a good decision has those hallmarks. So I will switch over to some thoughts on the BZA, unless anyone has any thoughts on the zoning commission things I've shared so far. Okay. So the BZA typically acts in a quasi-judicial capacity, which I always explain it as you're sitting like a judge. So you should sit like a judge and imagine yourself that if you're on the Ohio Supreme Court, and most often my explanation around this comes to, can I meet with an applicant? And the answer is, if you're sitting quasi-judicially like the BZA is, no, you should not. Because and thinking it through, can you imagine that, or say, I'm going to promote you, and now you're on the U.S. Supreme Court. Those judges do not meet with, me, plaintiff's attorney, someone else, defendant's attorney. They do not meet. They need to make a decision on what comes before them that day. They need to make a decision on the evidence and the testimony and the arguments that they see. They cannot be lobbied outside of the hearing, unlike those who sit legislatively, right? Any of the legislators down at the Ohio State House, they can be lobbied, right? There's a whole, that's the American system. BZA members you should not engage with, and if someone calls you or someone talks to you or they're your neighbor over the fence post, you just need to tell them, hey, you can't make any decision by yourself. It's a board. Even if you're the chairman of the board, you don't have any extra authority to make a decision than any of your other co-board members. So that applicant really needs to bring their case to the hearing. That would also result in them having their case on the record. It needs to be on the record. It needs to be sworn, because like we've sort of alluded to, BZA testimony should be sworn. You should have someone swear in whatever form of oath you use, that they're going to tell the truth. And that's one of the things we need to dot our I's and cross our T's, so that if that person or their neighbor who's mad about it wanted to appeal it to Common Pleas, we have right or wrong, we have our record. We have established that we followed all the procedures. We swore people in. We called the cases in an orderly fashion. We let people speak who generally wanted to speak. We let the applicant respond to any of those questions. We made a decision on the record. We allowed BZAs have to allow cross-examination. So and this happens, most people aren't used to that. So if it happens because it's such a contentious case that someone has legal counsel and their counsel knows that they can cross-examine someone. Or it happens in a more informal way. I've seen it where someone comes up to the podium and says, can I ask so-and-so a question? And while generally I would say, the questions need to be directed to the board. We're not trying to run a circus here. And sometimes, unfortunately, questions at each other devolve into not a productive situation. But technically, in some situations in the BZA, there is the right of cross-examination. So the applicant can be cross-examined. Contrastingly, so can an opponent, right? The applicant could come back and ask that opponent questions. So that's a component I would keep in mind that goes along with the quasi-judicial nature of the BZA: the swearing in, the formality, testimony, and the cross-examination. Yeah, Ernie. Yep.
Yeah, a question on that not meeting with the applicant. Let's say that as a BZA member, there's a case before us. We know it's on the agenda coming up for the meeting, and I'm going to go take a firsthand look at it because I want to physically see what it looks like, and a homeowner walks out the front door. I mean, technically, I'm there to observe what I'm going to be looking at from exhibits and stuff, but I want to firsthand look at it, so I'm not meeting with the homeowner.
I know that a lot of people like to do the visits. I would dissuade people in most situations from doing an exhibit a visit. If it really came down to it, I think the BZA, I have no problem that if the BZA decided it wanted to, as a group, think of like a visiting judge situation, right? I think Judge Piper, when he used to be the environmental judge down in municipal court, I've heard the stories where he liked to take court out to the zoning violation location all the time. But on your own, I would have the same concern about BZA members getting information their own way through their own sources, as opposed to the body hearing the testimony and making a decision on the record. I know that a lot of people and if you drive past the property, I'm not sitting here telling you need to avoid it like the plague. You need to go 3 blocks around. I'm not saying that, but I would not make a special trip to go visit it, because that runs afoul of, getting all your information in the hearing context.
Well, and again, if, a drive-by where you won't have any contact, even coincidentally with a homeowner or something, would seem to me make more sense.
I think there's less risk of that in that situation. Yeah.
So Jen, this is Chet. I mean, the time that the BZA, correct me if I'm wrong, the time that the BZA really has to be concerned is when it hits their docket. The case is scheduled and it's going to be before them, and they're aware that it's going to be before them, correct?
Absolutely.
Okay.
Yeah.
And Jen, this is Beth. I was just gonna say that I think that falls on staff to take pictures, take videos, to present to the BZA.
Absolutely.
You're not put into those predicaments where someone's coming out and you're having to engage in a situation.
Absolutely. That's why I totally agree. And that's why staff's there. They're a good resource. They're an excellent resource. And while we're on that subject, I will delve into the private deliberations. So what the BZA can do is adjourn into private deliberation amongst themselves during the hearing. They can take legal counsel in with them. That's often how I get involved. Or I'm often asked in a contentious case. So, and where this usually plays out is if for whatever reason you think the decision might get appealed, people are mad enough, or the stakes are high enough, or somebody's already done something and they're going to appeal it because they already have skin in the game, then that's the time when I usually say, you guys, do you think this is something you need to do a written decision on? There's no obligation for the BZA to write a written decision of their cases each and every time. No obligation. The record you create by your oral decisions, and the rationale, especially in the case of a denial, but also in the case of an approval, that's your decision. So in the case where it's so contentious that we want that extra level of, belt and suspenders, we wrote down our findings of fact and conclusions of law. The lawyer drafted it, so you can take it up with her. Then that's when I say, we might want to talk about a written decision. And for me to be able, I'm sort of reverse engineering it. For me to be able to write a written decision, I need to know which direction y'all want to go, at least preliminarily. And that's how we use the private deliberations to have that conversation. Again, think of the U.S. Supreme Court. That they're not sitting up on the bench, each and every justice, well, I don't really know. I'm thinking of going this way. And someone else says, well, but I'm thinking, they don't handle that. That they have, we know that they have discussions amongst themselves with their staff attorneys, not sitting on the bench for all to see. There's the nature of the quasi-judicial BZA hearing requires some degree of the ability to make a decision or have some deliberations, I should say, in private, out of the public view. The decision cannot be fine. You can't take a motion, make a vote in private deliberations. You can direct the attorney a certain direction on a written decision. And even if you weren't going to go the route of a written decision, you could talk amongst yourselves and sort of talk to each other. Well, I was really swayed by this point or this answer, or this fact or proposal, but so-and-so says this, and then, you can absolutely have that conversation. With the asterisk that COVID has made all of this more difficult, but what I have seen townships do, because you still have the ability to do private deliberations. That's in the Sunshine Law Manual, which is a good resource if you ever want to look through there. So what I have had BZAs do is either continue the hearing, don't table. Don't ever tell me you're going to table something. In the case of a hearing, you want to continue it, because that way you don't have to renotice the whole thing. There's enough of a chain, a jump, that you don't have to renotice it. Continue it to your next meeting or another meeting or a special meeting. And in the meantime, hop on a Zoom with me or with a lawyer and have those, or with each other. It doesn't have to involve a lawyer, and have those private deliberations. They don't have to be in public. They just don't. And then go back and make your decision at that next meeting. Or you can close the hearing if you think you have enough, if you don't think you're going to have any more questions, need any more answers, need any more information from the applicant, you can always close the hearing. BZAs have a reasonable time, that's the legal standard, in which to make a decision after the hearing. That doesn't mean you can't make it at, you can make it at. But there's no 30-day requirement. I have seen zoning codes where the township has codified that the BZA will make a decision within 30 days. And I'm like, why would you do that? Don't do that. Give yourself as much time as you might need. And if you get that decision done in 10 days, so much the better. And you want to schedule a special meeting for 10 days later, great. But I personally don't restrict yourself any more than the statute makes you kind of a person. So that's why you can use private deliberations. Yeah, Chet.
So just to be clear, I mean, this is something that Tom has asked me, to be frank and upfront about the way the Board of Trustees would like to see it run. And I think we are more comfortable when Tom and his folks decide that it's a very contentious case and maybe there's just a lot of tentacles to the case. And if there is a feeling that it could be appealed, would be appealed, whatever the case may be, just as you said, Jen, first of all, let's take our time. Let's take a big, deep breath. Let's take advantage of the opportunity to have private deliberations with our legal counsel, and then continue the case and allowing the BZA to work with the attorney on a written decision. And then we're comfortable if you all come to terms with a written decision in that scenario, because it gets all of the points down on paper. You're not under the gun, people's not staring at you or yelling at you or whatever the case may be, and you're able to think through the entire case and the entire decision. So take advantage of time, take advantage of our legal counsel and the resources that are there, and make the decision you want to make, but make it in writing so it's something that our legal folks can go back to and see, this is exactly what they did, this is why they did it, and this is what we stand on. Yeah,
right. The most recent written decision I did for a township was the BZA was asked to evaluate a use variance, and we haven't talked any about that, but there's two standards, right? The use variance is much higher than the area variance standard because a church wanted to operate a for-profit gun range in the back of the property. And whichever way you go on that issue is totally fine. My response to each and every time I thought of that was just like, America, like where else, right? I mean, isn't that wonderful? The biggest problem was that there are homes around that church with little kids and people who, they're trying to go home at night and enjoy their home, or on the weekends, which is when a lot of these shooting classes were happening. So yeah, we didn't know who was possibly going to appeal and which way it went, but we wanted to be sure that we had that as locked and loaded, if you'll let me do it, as we could. And so that's the most recent written decision that I wrote. No one appealed it. So, but better to be prepared, right? And the value of a written decision is because what we don't want a court to be able to do, if it got appealed, right? More the merrier. The courts are there for a reason. People are allowed to exercise their right to appeal, but we want a court that is faced with reviewing our decision, our BZA decision, or any decision appealable under Chapter 2506. Could be a zoning officer's decision, could be, all manner of things, right? We want them to make a decision, the court. We want a judge down in Franklin County, one of the Franklin County courts, to make a decision on the record that we had. The alternative, if our record isn't clear, and I have had a township where the extent of the record in a case, not local, they were down south, was essentially the minutes. They had not recorded the hearing, they hadn't videoed the hearing, nothing. So it was really the minutes. The minutes then had been adopted round robin style over email, which is a whole other problem. But if that had gone all the way to court, it did start to go to court, but it got settled, thankfully, because if it had gone to court, I have a real fear that it would have been so unclear or so limited that a court would have said, hey, we need to open up the record. And by that, I mean, take new testimony, take new evidence, let the applicant bring in anything they felt like they didn't bring in the last time, which means that gives them it's almost like a second bite at the apple, right? They get a second opportunity to make their case, when what they should have done was make it in our case. And then we could have made the decision, right or wrong, same or different. But let's give people one bite at the apple. And so to that end, that's why we make a good record. So that if a court has to review our record and our decision, they have to do it on what we knew. They don't get to substitute their judgment for ours, but by getting new information. So that's the goal. That's when I harp on that, when I focus on that and emphasize that, that's my goal. I don't ever want to be in the situation, and it may happen, where I have to argue to a court that no, they shouldn't open up the record. Our record is clear, and I don't want to lose on that, right? So I want all of us, what we can do here and now in advance of any court situation is make the clearest, tightest, dotting I's, crossing T's, checking all our boxes record as we can. And that's why.
John, I've got a question. What's the procedure to move to private deliberation? Is that the discretion of the chairman, or if I'm sitting as a member and I just feel uncomfortable and I think we need private deliberations, how do you go to that?
Anyone can move. It does not need to be the chairman, but I would move. Mr. Chairman, I'd make the motion that we move into private deliberations. You take a second, you take a vote, and then you get your co-members, take their temperature on the issue real quick, because they'd have to vote on it and say, oh yeah, no, yeah, I agree. And most times when it's situation, if you have that sense, most people have that same sense that there's enough going on, or we've gotten enough testimony both directions, or enough things have been read, we have enough questions. There's usually sort of a tipping point where we're all off the tipping point. We all have that same feeling. I've never had a motion for private deliberations lose. I've never had someone say, no, I don't think we need it. Let's forge ahead. No, I've never had that happen. And then that would just go into whether you're if we're back out of COVID and you're holding an in-person hearing, you can, adjourn yourselves to a separate room where no one can hear you. The regular audience can't hear you, and have your conversation, however long it takes. And the audience will just have to wait until you come back, and whether you're going to come back and make a decision or not. And they have the option to wait for you to come back out of private deliberations or not. They can always leave. And that's where I was going. In virtual world, it's a little more tough, because I don't know how reliable it is. And maybe people smarter than me know how to kick everyone to another room so that you can hold virtual room. So you can hold, I don't know how to do that. So what I've had people do is continue the hearing, finish it for the night, but continue it, do your private deliberations another date and time, and come back at your next meeting and do the rest.
Yeah,
I know I'm getting very close.
I had a question, Jen.
Sure, Tom.
And I think it's more of maybe a procedural thing, but after all of the testimony and cross-examinings, after all of that is concluded and we're ready to make a motion for the case one way or the other, obviously, if we're going to make a motion to deny something, that's when we get all of the resistance and pushback from the applicant. And that's when, as we've seen in the past, they sort of want to restate their case or testify some more.
Right.
At that point, are we legally or technically required to allow we can cut them off at that point, can't we?
You can.
And is that by closing the hearing and then introducing a motion, or
first, if a motion is on the table, that motion is on the table. We should give deference. And at the risk of losing our train of thought, right, on a motion sitting active, and us either not closing it out or forgetting what we said, and having people be required to vote on something and no one can remember what was the motion in the first place. But also, once a motion is live, that case is, you can either form, if you think, and I know exactly what you're talking about, Tom, if you think it would be useful to affirmatively, if someone's ready to make a motion, you can close the hearing. The only thing you need to be careful about closing the hearing is then that closes it, right? You can't have,
Discussion.
you can't have more, you absolutely can have discuss. The BZA can discuss as many times as and when and how it wants.
Okay. But once you
But
close
getting
it,
more information, getting
once you
more
close
evidence.
it, then you can't have any more with the applicants or anyone else then, right?
Yeah, it would arguably close that off.
So in that situation that does rear its ugly head every once in a while, what is your best advice for us to do, for me to do in terms of if I have a problematic applicant, is it better to just close the hearing or not close the hearing and then just make the motion? And then if they try to interject when they sense it's going to be a denial, then be forced to cut them off and say, no, there's no more testimony.
I would probably do it that second way, Tom. I think that's probably easier, and it's one less thing to try to remember.
Okay.
One less step. And then your answer is when someone tries to, interrupt is, listen, if you're confident, you've given them every opportunity to say what they needed to say. And we had someone, Tom, who you were alluding to recently, who said later, after his application was denied, that he didn't get the opportunity to speak, which I thought was rich, considering he not only had the opportunity to speak multiple times, he then was given a little more leeway. And that's why it's all fact specific. These are your neighbors, right? They're not my neighbors. They're your neighbors. And I fully recognize that sometimes there's just situations where someone just needs to say something. They just need to get off their chest. It's very situational, but there's also a balance, right? Because we need to, you have business you need to transact this evening. You have hearings you need to conduct. It's not all this one, unruly Jennifer Huber show. It's not just one person's show that evening. So it's certainly a balance. And yeah, you would have the opportunity at that moment to say, respectfully, Ms. Huber, we've heard you. A motion's now on the table. Your hearing's closed, and we need to handle this motion that's in front of us right now.
Okay.
Yeah.
Thank you.
You're welcome. Yep.
Hey, Jen, along those same lines, negative motions versus positive, instead of saying we move to deny, then you got to vote yes to deny. But if you just did a positive motion, you move to approve. And if you want to deny it, you vote no. I mean, as an attorney,
That's a very fair question, Ernie. That's a question I get very regularly. I happen to think, so I think there are absolutely both schools of thought. There are those groups that think, lawyers who think, people who think, practitioners who think, who like all motions should be in the affirmative. I will always pick whatever is clearest. So I will always pick clarity over everything else, making a clear record, making sure everyone knows what the motion is. And so for myself, I move to approve or I move to deny. Because if I had, I've never not seen this done, but I wouldn't put it past some real smart lawyer to say that a motion to approve, and if it fails, that just brought us down to neutral. You know what I mean? The motion was to approve, it failed, we're still back to zero. That you would still, I've not seen this done, I'm not encouraging those watching to do it. I'm just saying, I think that there could be a clarity argument to be made.
Yeah, I get it. That if the motion to approve fails, you really didn't deny the variance.
Arguably, yeah, right. And I'm not trying to call into question anyone who uses the always affirmative process. That's sort of my take on it. That's based on, my practice, what I've seen and heard and experienced. So that's my preference. Your preference is your preference, and whatever you can do clearly, I will always pick that. I'm running out of time and I don't want to keep you. So is there anything that I haven't gotten to or that I touched on that you want to talk about a little bit more? I'll take requests.
Hey, Jen, I got a couple things. I just want to point out to, especially the BZA, but one of the things that Beth and I talked about was to ensure that the boards receive a written report from staff. And so when I sit on the County Planning Commission, I always wonder why they have this written report and they read it verbatim. And I learned quickly that it was to make sure that all the details were entered into the record and that everything was very clear as to dates and reasons why recommendations are being made. So we're working internally, and I know Beth can speak more to this, but to ensure that we have basically a summary of the case that staff will present to you. And you can read that, have that, for you to look at as you're listening to testimony. And so we just think we're going to get a little more professional and get everything kind of down in writing. And then the only other thing that we talked about is to take the pressure off you, Tom. And I saw this last night or Monday night, is that our chair always looks for a motion on a case. And I don't want the chair ever to be the focal point in the sense of he's the bad guy. He's the one doing this. So, and this is where it comes in, the members of the boards need to be actively engaged and take the initiative to put out a motion for you. And Tom, you can just simply say, I'm looking for a motion on case number, blah, 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 blah. But your folks need to kind of initiate that. And that takes the onus off you. You have a lot as chair going on. You have a lot of moving pieces that you have to worry about, making sure things happen. This is where your members need to kind of step up and make those motions for you, and then deal with the business at hand. So we're hoping that kind of will kind of work that way, but it's the board members need to understand this is a different role. They're going to need to be more active in that part to move the proceedings along, because again, Tom, you got a lot to deal with as chair of the BZA. In the same way with the zoning commission, the architecture review board, chairs have to do a lot. And we're hopeful to get that support for you. So.
Hey, Chet, this is Gary. One way to kind of maybe help out with that, and I handle here with the Franklin County Commissioners, I handle the Board of Elections going to their meetings. Their agendas are pretty much scripted. Whereas if there's something on your agenda that needs voted on, it actually says who's going to give the motion and who's going to give the second. And they read, as you said, like with the Planning Commission, scripted, so they have it exactly how it needs to be said. And that may help you, Tom, with the BZA and working with Beth of having that ahead of time. That way it's scripted and out there. That way you're not left in the lurch as the chair to be the one go, hey, I need to make this motion. Instead of you being the one making the motion, it's somebody else on your board.
Right.
What do you think about that, Jen? I mean, I haven't seen that. I mean, I've always had the chair ask for.
I've seen some of that. I think less in townships. I feel like I've seen that around. I think I would leave it up to the board. I would leave it up to the board if they like that way. I don't have any problem with that. The only thing off the top of my head I could think of would be what would your contingency plan be if someone, for whatever reason, you scripted the agenda and then someone ended up having a conflict or wasn't able to come that evening. But I have no concern that couldn't be addressed or figured out. Yeah, I think it's a stylistic choice. I think it's a smart. I mean, there is it's done right. I mean, it's set. There's definitely pros to that. I leave it at the discretion of the board and see what they want to do.
I don't mind keeping it somewhat fluid as cases sort of evolve. And I by no means, I'm shrinking from my responsibility as chair. I mean, I don't mind. I think we ought to mix up making motions. I mean, it would be nice if I don't have to make them all. I mean, that's nice, but I don't want to act like I don't ever want to make a motion. So I think, depending on the case, I think we just take it as it comes and go from there. And I personally like to make motions the way that you recommended, Jen. And I know Pete and I have had that conversation in the past too. And, if I am going to deny something, I want to clearly state that versus an approval. And I just think that's it's not like a bait and switch, or it's not confusing, and it lays it all, puts it all out there, and there's no confusion.
John, were you trying to flag
Got a
me down?
question, Jen?
Yeah.
Yes, I've got a question.
Go for it.
If we any agenda that we write up before the meeting, is that a public record? Does that become a public record if someone makes a FO freedom of information or public records request?
Well, yeah, but it would only say who was going to make the motion. It wouldn't say which motion they are going to make, because obviously I don't know what that is, and you don't know what that is. It would it's sort of like assigning in advance that you, Jen Huber, you're going to make the motion, whatever it is, however we hear, you're going to, or whatever you want to make on case number 1.
Okay.
And John's going to make it on number 2, and Chet's going to make it on 3, and Tom's going to make it on 4.
Okay.
Not which direction.
I thought that Gary said, and maybe I misunderstood, that the agenda said that Chet will make a motion to approve this, and Ernie will make a motion to
Yeah, that's how I mean they do it. It's scripted in that it's internal. It just has it laid out, and then they vote. However, it doesn't mean it doesn't make a predetermination. It's just because it has to be brought before the board, so they make the motion in a second, and then there's discussion of how that needs to go about.
Yeah.
It's just it's a way of simplifying it for the people on the board, and so that when it's part of the public record, it's written out exactly how you want to have it. And Tom, that wouldn't preclude you from making a motion either. They do that the same way for the Board of Elections, that the chair actually makes a motion and then somebody else makes a second. It's just one way to maybe simplify it. If in the future it gets to be a lot of things going on and parts moving, to help you move things along also.
Speaking only for myself, I think sometimes what I see when there is,
Hey, sweetie.
I'm not hesitation, but when I see people who are like, well, I don't know if I want to make the motion, I think a lot of times if I was going to armchair psychologist it's because sometimes, I mean, I don't envy y'all in your positions. You may not know or think you know or have any handle whatsoever on how you think your other board members are going to vote. And I totally understand. I mean, we've all had those situations where you're like, well, which way do I go? Or what do I say? Are they all going to think I'm crazy for moving to approve it? Or are they going to be like, Jen, did you not hear what he just said about? So what I think, to respond to that, I would emphasize for any of the boards here tonight, I think the key to a good hearing is good questions. I think the more questions you ask, not only give you more information, because you also know you're going to have to pull some of this info.
Coach Alex, what?
Whoever is Scott's iPhone, do you mind me? There you go. Thank you. You're going to both pull information out of that applicant, because you and I both know they're not putting all of their cards on the table in their application. Totally get it. But also you're going to give, you may also give your other board members a sense of where you're going with your thought process. I know that in law school, I did some oral arguments both for class and in moot court. And anytime we called it like a cold bench. Anytime the moot judges are sitting up on the bench and they're just like, and I'm not saying that any of you are like that, but you're just like, that's the worst case. That's the worst case scenario ever. And you would think, oh, hot bench. You really want question after question after question. Yeah, because then you know both how, if you've ever seen any court judges asking questions, then you know how they're thinking, what line of analysis their thoughts are running on, what direction they might be voting, depending on their question. You never know. But that they're also signaling to each other where their priorities are. I have a BZA member in another township who always asks a question about septic. If he knows that if he has looked at the property, that's his realm of expertise too. So, which then brings a whole other host. I mean, all of you are coming with your own expertise, your own work on your own houses, your own projects, your own professional lives, or real lives, or both. That you have expertise that your co-board member might not have, and that's so I can't overestimate
Emphasize.
how valuable all of that other insight is. You're going to ask a question. I know I can say this with every confidence. You're going to ask a question both that someone else was thinking and that someone else was, didn't even know you don't know what you don't know, didn't even know to ask. And that could be the difference between, oh, well, had I known that, I would have gone a different direction. All of that is so valuable. And the more questions you ask, the more conversation happens around that. Now, I'm not saying no one wants to have a 3-hour hearing, no one wants that. But the more thorough your hearing, the more developed your record, that just goes back to all my comments about creating a good record. Even if it went to court, I could point to all day on a good record, solid, lots of questions, good analysis, good backup for whatever decision was made and the rationale that member had, whichever way they voted. If they voted on the winning side, it doesn't matter. I can point to all day, that comment showed, Your Honor, that comment shows that, Ms. Huber or Mr. Cheney were thinking through those questions and those factors on the variance, or else they wouldn't have asked that question. So I think for all those reasons, a hot bench, if you will, lots of questions, pepper those people. If they've answered all your questions, you have what you need, then you have what you need. But something's still sitting in the back of your mind, or you read something in their application that you're like, there might be more to this. The floor is yours. It's your bench.
Jen, I guess I'd have a problem with a pre-written motion, even if it was internal. I mean, it gives the perception that, even though you have to take a vote, it gives a perception that the issue is already decided if you got a pre-written motion.
So as far as
depends on, Jen, hold on. It just depends on how you write it
Exactly.
up. The motions that they do, the Board of Elections does, when they write them, it says approve or deny, one of the two. It has a slash. It doesn't state right out what they're going to do. So they have a discussion before they actually have the motion. It allows them one way or another to say they're going to approve this or they're going to deny this challenge order, something like that.
Okay.
Yeah, I have seen a couple different ways, Ernie. I have no problem, and I've had people ask me, depending on a case, had people townships ask, Jen, could you put together both options, the denial and the approval? Now, I can't put the rationale. That's going to have to be each board member who's going to say, I deny it, or yes, and here's why. I can't jump into each and every one of your minds. So you're the ones who's going to have to say when that motion goes on the table, if you agree, yes, because, or no, because, or however you want to word that. So I can't ever put in the rationale because I don't know what's going to come out in that hearing. I don't know what somebody's going to be drawn to or gravitate to as far as a thumbs up or a thumbs down. So I've seen it that way. If there was a pre-written motion, and again, that would be privileged and confidential. If it's coming from me, it's privileged and confidential because it's attorney-client communications, attorney work product. On the other hand, what I have seen and I think works well for another board that I work with is the agenda when it gets written by staff. So it'll say case number 1. It'll be opening, roll call, whatever, and then at 1. Case 01 variance 2020. And it'll say, an application for variance submitted by Jennifer Huber for property located at 123 Smith Street, seeking a variance from the provisions of the zoning resolution 1234, namely, or to wit, it'd be sort of like to wit, this and this. She wants a side yard setback that's 5 feet instead of 10 feet. What you then could do as a BZA member, what these members of this township do is they take that agenda item, and when someone's ready to make a motion, they take that same blurb and they say, I move to approve, and they fill it in. Case number 01 variance 2020, a motion by, or an application from Jennifer Huber from provisions of 1234 of the zoning code to seek a 5 feet. And then they can tweak it, right? 5 feet, or they can say no more than a 5 foot variance, or not to exceed, or as submitted, or, you know, you can tweak it, but that's at least the framework. So I've seen that, and that works well for folks too.
I
Any
just,
discussion?
I just want to add a couple things. This is Beth. You know, Tom, you were talking about the case y'all had where the person kind of kept talking, and Jen and I had a conversation about that. I'm like, you know, how do you make that stop? And one of the suggestions she came back, or, you know, and kind of take the arguments away. There was a couple things. One was before the hearings closed out, to say if it's somebody like the case y'all just had, is like, what other options have you looked at? What other alternatives have you considered? You know, and kind of get that part on record. But then near the end, when you think everything's winding down, just to simply say, before I close out this hearing, or whatever that wording might be, is there any final testimony? So everyone knows that this is their last shot at it. And then if there's no answer, or you get responses, that's fine. But no one can come back to you folks and say, hey, whoa, wait a minute. Now that last one, I think you probably would have gotten an argument even with that. But I just thought those were a couple of good ideas she had. And I noticed she had some other documents that I forwarded along that had kind of the dialogue that y'all might want to take a look at, and you can pick and choose what works best for you folks. The other thing
Makes sense, Beth. I just, now that we know what we do, what we know that we can do, you know, we can make sure we've given them every opportunity, and then we can shut them down if we need to. But, you know, in that case, it was almost a situation that no matter what we were doing, we were going to have that person argue to the end, I think. But
now, you know, to that point, I've sat in, obviously, you know, over the years, a few different hearings, and if someone gets totally unruly, the chair has every right to give the person a warning, correct, Jen? And if they don't follow a warning, you can have them removed. And that's another thing. If any of you folks think that you're going to have a hearing where people can kind of get out of hand, just let me or John know, and we'll have an officer there that would take care of that kind of a situation for you. That's not a problem at all.
And Beth, that's an excellent point. I mean, if we believe there's a contentious hearing coming up, Tom, you can make the request, or we'll suggest it to you. We'll be a little bit more diligent about looking for that. I know that a person in a uniform with a gun on their hip or a taser calms everyone down just a little bit, and gets them to understand that they need to have a certain decorum, certain behavior that's professional, and not attacking people. This is a formal process. Everybody gets their say, but you have to do it in a professional manner. So,
well, and that we've sort of been there in the past on some high profile cases like that. But when we're doing these Zoom hearings, you know, that's where
it's hard.
It's a little more challenging. Yeah.
Well, you know, Tom, I can kick people out of meetings. I have that ability. I learned where the button is. And I still think, you know, again, Jim, correct me if I'm wrong, but if someone's getting to that point, then give them fair warning. And if they continue, we can either mute them or kick them out of the meeting.
Yeah,
I mean,
no different than, like Chet said, then you would have them removed by an officer, by someone who, you know, I would have those thresholds be pretty high, but unfortunately, people find those thresholds pretty easily sometimes. So yeah, but yeah, you have that authority.
And at these meetings, Jen, also at the beginning of them, for zoning and for BZA and for architectural, we need to remind everybody who's on that these are official meetings and are being recorded, and the same rules apply whether we were in person or on Zoom.
Yes, and I think it's good. I mean, we've had this conversation as well in varying degrees. It's very useful in my experience to whether you're in person or especially on remote, on virtual, to set the expectations up front. Here's how it's going to go, because unlike other bodies, you're probably getting people one and done, right? They're coming to you one time, they get there. I mean, I don't know how many repetitive, repeat customers you might have, maybe not many, unless in the zoning commission realm, maybe a developer has come before, right? But individuals, probably you're only going to come, maybe they only come and see you ever in their ownership of property in the township one time. So they're not going to know how this works. That may also be the first time they've ever interacted with, any governmental agency at this level, or in this level of, of intimacy. They're right here. This is your application. These are your neighbors who are going to work through this process with you. And the more instruction, the more guidance, I think the better. I think it makes people feel more comfortable. They're coming, I think almost everyone comes to hearings, meetings, etc., a little bit nervous, not knowing what to expect or what they're going to be asked. And so the more information we can give them up front about how things are going to go, and then you don't have to fight for their chance to speak, they're going to get it. I think that goes a long way.
And that's something us as staff can help with too, when talking to the applicant before they even get to the boards. Saying this, matter of fact, Gary had me, when we just did one for the zoning commission, he brought up about the speaker rules, which we've always pretty much used for the board of trustees. And because this is all what's kind of new to me, I didn't even think about transferring that over. So I kind of rewrote the board of trustees speaking rules for the zoning commission. I want to do the same thing for the BZA, and to just put that up front. And it doesn't have to be long at all. Gary just kind of came back and kind of reminded people of decorum, and if you want to speak, you have 3 minutes. Now, applicants, I'm sure, would be much different. But if you have someone who's there to oppose an application, you should have every right to limit how long they're talking. The people who really need to present the case is the applicant themselves.
We don't have the ability to put time limits on BZA testimony, because what someone may say in an appeal is that they weren't given the opportunity to testify. And it doesn't matter that they were given 3 minutes. If they are going to have the ability to argue to the court that they needed 4 to get to that 4th argument, that they weren't allowed. So I never let BZAs get time limits. So that's a key difference. But what I would say what I do tell people is that you can emphasize that we don't need any and same for zoning commission, really. We don't need repetitive. We encourage that if your testimony is repetitive, know that we're trying to get through everything tonight. Encourage non-repetitive testimony, but I would not put a time. I wouldn't put a time limit on it.
Hey, Jen.
We won't bring back the chicken coop in Perry Town.
I resisted talking about chickens earlier, Gary. I resisted it. I asked people if they wanted to raise horses, right?
Yeah, we don't have any ag in Perry Town. Right, Chet?
That's right. So, but to that point, so Jen, would you be willing to work with Beth on, I'd really like the chairs to have a written list of this is what we're going to go through when it comes to expectations for the hearing. And I get what you're saying about not having time limits for BZA hearings, and I get your point. But I'd really like for both chairs to have that list, especially because we're virtual. And it will happen in person too, but just to reaffirm, this is the process, here's the expectation, it's a professional hearing, blah, 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 blah. In the zoning commission, you may wish to have it limited, but whatever the case, have it spelled out in writing for the chair to read verbatim. And that way it gets all handled.
Absolutely.
Okay.
And the only thing I just wanted to add is, like Chet mentioned, we're going to try and do better with the staff reports that are going out to folks for the members for the hearings. If there's questions that you have, or you need more documentation, or you need us to take better pictures, or whatever that case may be, just don't hesitate to call John or me to get that information, because I think it's just going to make things more streamlined for you folks once you actually get into that hearing. And John and I aren't always going to think of absolutely everything you need as you're thinking through this stuff. So just don't hesitate to reach out to us if we can provide more clarification, or like I said, videos, pictures, whatever you might need.
Right.
I did not, just as a couple closing notes, I did not get to go into the Architectural Review Board or the BZA sitting as the Exterior Property Maintenance Board. So if there's any questions about that, please feel free to reach out. I'm always happy to, like I said, I get the privilege of doing zoning a lot of the day, almost every day, and happy to go through any questions that anyone has. Additionally, I put a couple links in the chat on this Zoom. So if you go to the bottom and click the little chat icon, your chat bar will show up on the right. And I put a couple links there. They're just to YouTube. There are a couple Ohio townships. I think one is a good example of some good BZA questioning of an applicant who was working on they did not want to put a certain kind of fence around their pool, I think, if I'm correct, or they already had a fence that they liked, or, oh no, they weren't going to put a fence at all. They were going to they have a really strong pool cover apparently. And then the other video is, I just thought it was a little bit disorganized. I know that townships across the state do it every different direction, but I thought for our purposes, it made me like, if that was the record, how would I try to parse some stuff out? So just a couple things you can find, I mean, as many more as you care to watch by Googling.
Hey, Jennifer,
Yeah.
I've got one real quick question on something you said earlier. You gave an example of a motion for the BZA using the text that staff had provided. And it was real quick. You read what they said and you motioned to approve or disapprove.
Mm-hmm.
The BZA, for as many years as I've been on the board, we've had like a page and a half script that we read for the motions.
Mm-hmm.
Is that overkill? Is the smaller one better? What covers us the best? What is correct?
So I'm not sure if I have ever seen that script, but what I would, and I'm happy to look at it, what I would say is whatever, I mean, there is no, while some statutes in the revised code have forms, right? They'll say exactly what you need to say in something. There is no form, statutorily prescribed form for what the motion needs to be. So I just go back to, is it clear? To both the applicant, the audience, all three, the applicant, the audience, and more importantly, to BZA members voting on the motion. So no, I don't have a form that you absolutely have to follow, Matt. If you liked the form before, when you're making a motion, or when however you want to do it, I have no problem.
Yeah, I think the form we got, Glenn used it for years, and I think it may have even come from Pete years ago.
It totally could have, or Don, it really could have. Totally.
Yeah.
Mm-hmm.
We've historically always used that, and it lists the 7 points of the why the variance is either approved or not. And likewise, historically, Glenn, as the prior chair, had pretty much always put forth the motions. And I know whenever I put forth a motion to my board, I mean, clearly I'm tipping my hand to you where I'm coming from, what my thinking is, where I'm going with this.
Right.
And that's why I make the motions the way I do, either for approval or denial, so there's no mystery.
The only thing I would add is that, having not seen that form, you would want to be careful that you are using the correct standard. So the use variance standard is unnecessary hardship versus practical difficult, or I think I have it backwards, but the Duncan v. Middlefield factors, those 7 factors, those are for an area variance. So if you're looking at a gun range in the backyard of a church, that's the use variance standard, and it's the higher standard where they have to basically say, I came to this property the way it is. I mean, it's a way higher standard. So that's the only thing I would just be careful that you're using the right standard when you're almost always going to see area variances, as those are much more common. But for that one-off use variance, you want to be sure you're using it.
And I do have the templates for the different variants.
Oh, got it. Perfect.
Glenn had actually, when he retired, had sent me all of that information. And I think you might have even sent me some of that too, as we led up to a prior case.
Sure.
Where it was spelled out pretty clearly. So
Yeah. And the materials you have for today, it could have been what I pulled from. It could have been what I pulled from, where we have the two types of variances on page. It starts on page 6 of the packet.
Okay.
But that's my only when you're reading don't get sucked in by the form in front of you if what you need is a use variance. But other than that.
Well, as you are observing and participating in our hearings, I mean, I think we have a pretty good format down and have covered most all these bases. You know, if there's anything that we're not doing that you think we should be doing, me or anybody else, I mean, just let us know. But I think hopefully we're in compliance with the standard.
As you well know, I will stop you in your tracks and kind of tell you where we if I think we missed an exhibit somewhere, right?
Yeah, and that's very helpful, obviously, to cross all the T's and dot the I's. So.
And I think it's getting comfortable with that process, getting a process that everyone likes and knows is going to take all the guesswork out of that and make it so it's just, second nature that then we do this next and then we get a motion and then we take the vote and then we move to the next. I mean, that's what I think.
And I think it's when we have multiple cases in a given night, I think that's where it would be quite beneficial that I'm not the only one making the motions then.
Mm-hmm.
It would be a nice balance to have everybody take a crack at making a motion if we got 3 or 4 cases or whatever. But if we've got just a normal, typical one type of deal, then I think it's pretty customary and routine that we can get through it like we normally do and have in the past.
Well, Jen, on another note, I mean, this is a minor one, but in the swearing in process, should the chair swear in everyone who's going to be testifying before and just get that out of the way as part of the checklist?
Yeah, I think that's smoother. I think that's how you do it, right, Tom?
Well, I had did it on a case by case basis last time.
Oh, okay. Yeah,
so,
I think it's, again, in the interest of things that can be done in bulk, sometimes help cut down on individual. There again, multiple camps who think it's better or worse to do. And again, with virtual being what we have to live with right now, I think it can be done very smoothly to do a mass swearing in up front. Anyone who is planning to speak tonight, to testify tonight, please stand or please raise your right hand and do you swear? And then the belt and suspenders or the bookend to that is that as you have testimony, people providing testimony come up to the podium like you do, or like you've done, you have people give their name, their address, and whether they were sworn in. And again, I have townships across the state for whom I have interrupted multiple times where I'm just like, and were you sworn in? And were you sworn in? And they're like, yes, the lawyer, stop, leave us alone. But that's the bookend. So that even if, and I think you had someone recently where they weren't, or I've seen this recently, where someone wasn't on right up front when they did the swearing in, and they might have answered no. I forget if that was this township or was Perry or was a different township, but they said no. And that was a great example of when we could, had we not asked the question, we wouldn't have known until possibly the bitter end. Again, it's a little bit picking at details, but it's because it's low hanging fruit that no lawyer wants to lose in common pleas on an appeal because someone comes up and he wasn't sworn in. Oh my gosh, let's not lose on that, So what I've seen done successfully pretty consistently is the mass swearing in right up front, all the cases, anyone who wants to speak tonight. And then as they come up, you ask them, were they sworn in? And if in the rare instance they say no, then you give them the opportunity right then and there.
Yeah.
While we're on that subject, I will say lawyers don't need to be sworn in because we always tell the truth. I'm just kidding. But it's because I can tell who's paying attention. All of you are paying attention. But it's because if someone's there as an agent of someone, they don't technically need to. Most lawyers I've ever seen, they go ahead and do it. I've never seen anyone object to that. But if you got in a situation where someone was like, that one opinionated lawyer out there, right, who says, I won't do it, you can't make me, I don't want you to get in a shouting match with them. They don't technically need to be sworn in. They're not testifying for themselves, right? It'd be the same as if they were down in court. They're not on the stand, their client's on the stand. They're providing information on their behalf.
Zoning officer needs sworn in or not?
Absolutely. Yes. And I'm glad you asked that. The zoning officer, I meant to mention this when we were talking about private deliberations. The zoning officer, whoever's there providing the staff report, the zoning perspective is, and I think many of you have heard me say it this way, is sort of there as the prosecuting witness. You're there, the zoning officer is there holding the flag of the zoning code, defending the flag of the zoning code and saying, do you like my imagery on that one? And saying, this is the code, here's what it says. Even in a variance situation, right? We're not saying anyone can't come for a variance. They are exercising every right that they're allowed to be there for a variance. But the zoning officer says, here's what the code says. You're asking for something different, but I'm standing here defending is dramatic, but I like it. Defending the zoning code, prosecuting in a sense the zoning code to a degree. So they're actually arguably a party to the case. They're sort of the prosecuting side, which is why, and this trips up some people every so often, if the BZA goes into private deliberations, you cannot pull in one side, right? Because it would be ex parte. You would be holding a conversation with one side, but not the other. So you should not have the zoning officer come back with you into private deliberations, because arguably then there could be an appearance of impropriety or actual impropriety where you're relying on out of public view testimony that's not. So yes, because the zoning officer is a critical component and almost like a party in the case.
Okay, that's great clarification.
Yeah, no, good question.
Jen, when you get to the mass swearing ins, is it also appropriate, should Tom or Gary say, now, if anybody should choose to want to say something, they have to be sworn in before they can talk if they didn't stand up?
Yeah, so between the introduction you give, and it depends on how you say it, but if you say anyone, I have heard people say, and I think this is good, anyone who wants to speak tonight needs to be sworn in. If you want to speak tonight, hit them over the head, right? If you want to speak tonight, please stand, sit, raise your hand, however you do it, to be sworn in, and then, give the oath. And then at the same time, when you ask them, when they're up at the podium, whether virtual or in person, were you sworn in? You're again hammering it home that this is testimony. This is testimony like you're down in court. You need to be sworn in, and if you weren't, we'll swear you in.
Thank you.
Of course.
So are there any last minute questions at all? I think we've kept Jen probably a little.
Oh, I've kept you. I think I've done all the talking. I've kept you. Thanks for bearing with me.
That's fine. It's great presentation, Jen. We really appreciate everything. I know there's a lot that I didn't know that you certainly clarified for me. I was going to say too, in the interest of kind of streamlining things, if y'all come up with any more questions or things you'd like to get clarification, if you wouldn't mind emailing me, and then I'll send the list to Jen and share with everybody. That way we're not doubling up on her time, if that makes sense. And but I really appreciate everyone spending their night learning about zoning processes and all the good questions that have come out of it.
Yeah.
I think we haven't done this in a while, and this, like Chet said, I think this is a good thing to have probably once a year, if nothing else, as a refresher. So.
Well, my pleasure, and thanks everybody.
Thank you, Ben.
Thank you.
Thanks.
All right. Well, have a great night. Take care.
Y'all.
Night. Feel better, Beth.
Yeah, feel better.